The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Thank you. Good afternoon, everyone. The next case is in re George, and we will hear from the appellant.
May it please the court. Chief Justice Newby, Associate Justices, my name is James Galvin, and it's my honor to be here to represent the Georges in this matter. I intend to reserve about 5 minutes for rebuttal. This case will decide who owns the home at 12312 Ridge Cove Circle in Charlotte, North Carolina. I'm going to ask the court to find in favor of my clients because they lost ownership of this home without due process to purchasers that were not good faith purchasers. They lost this home in a judicial and non-judicial foreclosure sale of an HOA lien in the amount of $200 to purchasers that purchased the property for about $2,600, representing about 1% of the value of the property. They were found to not receive due process statutorily such that the foreclosure sale was voided, and the trial court found that these purchasers were not purchasers in good faith entitled to not have the deed set aside. There are two main issues I want to address for the court that concern the deeds and whether or not they're set aside. The first one concerns the purchaser's lack of status as good faith purchasers under 1-108. And the second one concerns due process and the fact that my clients did not receive sufficient due process such that they should be deprived of their property. I will first address the good faith purchaser issue. In order to prevent these deeds from being set aside, the purchasers need to establish themselves as good faith purchasers for value under 1-108. And the Moorhead case states the elements that they need to establish. First, they have to show that they're purchasers without notice, actual or constructive, of any infirmity. They have to show that they paid valuable consideration, and they have to show that they acted in good faith. These are applied in conjunction with one another. The standard of review is abuse of discretion. The trial court found, and I'll just address first the good faith. Trial court found that there was a lack of good faith such that they were not entitled to the 1-108 protection. The facts of the record support the finding of a lack of good faith. First, the KPC Holdings owner, Dow Shan's son, and the subsequent owner, National Indemnity Group's owner, Laura Schoening, they were colleagues. They had been partners on many transactions in the past. And when speaking with Ms. Schoening about her involvement in this transaction, the court did not believe that she was being honest about what she did in this transaction and what her partnership with KPC was like. In fact, National Indemnity was not conveyed this property until March 21st of 2017. But the writ of possession that was issued in favor of KPC Holdings in February of 2017 lists Laura Schoening as the contact person for KPC. This is evidence that they're in this together. Furthermore, KPC's attorney at the time was Jonathan Henkin. And in April of 2017, again, this is a month after KPC conveyed the property. In April of 2017, Mr. Henkin was actively negotiating on behalf of KPC Holdings to see if he can get the Georges to repurchase their own property. What is KPC Holdings doing negotiating the repurchase of a property if they purportedly don't own it? And further, there's the actual terms of the deal itself as described by Ms. Schoening. Again, Judge Poovey did not believe a word that came out of her mouth, to quote Judge Poovey in the trial record. And he also said that Ms. Schoening was able to acquire this property by providing $0.00. The deal allowed her to take ownership of the property and not pay a thing unless and until she decided to sell it at some future date that was not determined, meaning she could hold on to it without paying anything. And it's not until she sells it that both she and KPC Holdings then become practically, to all practical effects, financial partners in this deal. When they go to sell it, that's when everyone cashes out on this deal. These facts support Judge Poovy's finding that there was a lack of good faith, and I don't believe that there can be a showing that he abused his discretion. The second,
let me ask you this, and again, just based on the record that we have, I'm a little confused whether the property was owned outright or if there is a mortgage, and if the purchase was for the foreclosure of the HOA fees subject to a mortgage. I'm trying to discern the
Yes.
equity in the property, if you will. Can you?
Yes, Your Honor. And that is a key fact to this case. It was owned outright. And so the actual amount of what my clients owed the HOA was $204.75. And once you proceed to the foreclosure and you add attorney's fees, the sale price at the foreclosure sale to include that was $2,650.22. The house was fully paid for, and the trial record establishes the value of this property somewhere between as low as $150,000 and as high as $240,000. So when I state that it was purchased for about 1 to 2% of its value, that's what I mean, that it had full equity.
Although the dissent was disturbed about that to some extent, there was only one bid. There was no upset bid, and it was an auction that was certified by the clerk. Is that right?
That is what happened. It did go to auction, but I do not believe just participation in an HOA auction is a guarantor of value, especially when the facts show that you have 2 frequent HOA bidders that are potentially in collusion regarding the purchase of this house.
But while there was concern about the fact that it went for so low of a value, relatively speaking, the fact is there were others that were eligible to bid, and the fact that there was only one bid can't be attributed to the purchaser, can it?
Well, I think the facts support that potentially, if there are other bidders there, let's say at National Indemnity Group, NKPC, and they both realize, wow, this is a steal. This is a $2,500 purchase of a $200,000 home. Instead of us bidding and putting blood in the water and alerting other bidders that they're upset bidders, why don't we step back and why don't we make a partnership deal over here? That was not proven, but the facts that were established allow for, frankly, that's exactly what the deal looks like. So. Then that brings me to the second element.
Let me jump in and ask a real quick question. Was there evidence that KPC knew or had reason to know about any problem with the notice?
Yes, I believe. Yeah. So that's skipping past valuable consideration, which I think is easily shown that there wasn't. The big element was there notice? Moorhead requires that they were on notice that there was a defect. So the Goodson and Swindell cases stand for what notice is required, and it is it's where there's no actual knowledge of the defects, that you're not on reasonable notice from recorded instruments, and the defects were not such that a person exercising reasonable care would have been aware of the defect. So where the Court of Appeals got this wrong, I believe, is that they narrowed the reasonable notice to the foreclosure file alone. Even though what happened in this case and what happens in every case purchasing property is you look at the tax record, you look at the title. Goodson and Swindell cases say you're entitled to rely upon, quote, the public record and the monuments of record title. So when you look at everything, when you look at the entire record, yes, the KPC was on notice of the defect. The defect is obviously, and the court found it's not at issue, there was not proper service. There's no personal jurisdiction here.
Yeah, tell me why, based on the public record, KPC or National Indemnity should have reached that conclusion.
Certainly. For 3 things, Your Honor. First was the low purchase price. When you look at the public record, you see that you've got a property worth over $150,000 being let go for over a $200 debt. A reasonable person would not think that an owner of a property with notice of the proceeding would stand by and just let 6 figures in equity walk away. That's the first thing.
Okay, then before you go on to 2 and 3, let's stay there a second. Because this is the issue that I'm most concerned about in the case. Swindell and others say that mere inadequacy of purchase price isn't sufficient to prevent someone from being a bona fide purchaser in good faith. How is the argument that you have just made different than a contention that the purchase price was so grossly inadequate that it meets the second criteria that's in the test set out in Swindell?
Well, in two ways. One, the defect here is not simply, as in other cases, that the price wasn't enough. We're not just saying, stop this sale because the sale price isn't enough. We're saying, first, stop this sale because there's no personal jurisdiction. We didn't receive notice. That's the defect. The defect is not that it was sold for too little. The defect is we did not receive statutory due process. Second, the fact is that it wasn't just mere inadequacy. And Faust and Swindell talk about this, that when you have gross inadequacy, then that's a different matter altogether. Then that is supposed to be a part of the notice analysis. That it's different than, hey, this is being sold at 50%. That's not uncommon in auction. This is being sold at a 99% discount. This is grossly inadequate. And the case law in Faust and Swindell says when there is gross inadequacy, that fact alone, coupled with any other inequitable element, here the lack of notice, is sufficient for the court to interpose and do justice between the parties.
What other than this gross disparity between value and
Thank you, Your Honor.
Purchase price would show the type of defect that's required?
So the tax record, for one, Your Honor. A review of the tax record prior to the sale, which Ms. Schoening admitted she did, shows that the taxes on this property were paid in full in December of 2016. That's 2 weeks after the foreclosure order was entered. On a $200 debt, my client paid a $2,225 tax bill on this property and then lost the property 2 weeks later. It is a reasonable notice. A reasonable inquiry would lead one to believe an owner wouldn't let that happen if they were on notice. There must be a defect in notice to allow that to go that way. And thirdly, the history of a prior foreclosure in this case. That if you look at the public record, you would see that the Georges faced a 6-figure mortgage foreclosure in the past. Their response to being foreclosed upon with a 6-figure debt was to pay it in full. It is not reasonable to think that someone would pay a 6-figure debt in full to prevent a foreclosure and have a fully paid off house, only then to lose the house to a $200 debt. And then
What's your response that somebody accepted notice at the home and signed, I believe the name was Jennifer George?
Yeah, Your Honor, that is mistaken service. That's exactly what the court found constituted lack of service. There was not proper personal service, and there's no presumption there. We actually have the deputy on the stand admitting, yes, served the person. Personal service was not achieved, and no further steps after that were taken.
So the Jennifer George was not. I'm sorry, Justice Irvin, you've allowed me to go twice earlier today. Go ahead, please.
I'm getting ready to go. We're going to go for a third time. Go right ahead.
3 strikes, you're out, but I'll do it. Thank you. The Jennifer George, would that be the wife if the name is the same in terms of that, or could that have been the daughter, or was that clear on the record at all, of one of the 3 daughters that resided at the home?
It was one of the daughters, presumably, that was served. We showed the pictures to the deputy, and Miss Jennifer Hygienia George, the owner, was in court, and it was confirmed that it was not the owner. It must have been one of the daughters, but it was unconfirmed who actually answered the door, who stated that they were an owner of the property.
But it's your position that that was improper notice?
That is improper. Yes, Your Honor, I believe that's improper notice. I don't think that's at issue. That's what voided the foreclosure sale, and it's properly voided. The issue is was it such improper notice that due process would require setting aside the deed to the subsequent purchasers? And for many reasons, my position is yes, that it
Thanks,
would.
Justice Irvin.
All right, maybe I'm analytically off base here, but given what you just said, my understanding really was we had two questions here. One was there constitutionally adequate notice? If not, then you couldn't apply GS 1-180 to your client. Secondly, even assuming that you had constitutionally adequate notice, if your client did not qualify, if National Indemnity and KPC didn't qualify as a good faith purchaser for value, they were not protected from having to relinquish ownership of the property. Am I wrong in thinking that there are two issues here rather than one?
Yes, Your Honor. And right now, I've started with the first issue that they're not bona fide purchasers for value. They're not entitled to that protection.
And that's where I thought we were, but something that seemed to me to bleed the two together, and I just wanted to make sure, since this is not an area in which I have a great deal of expertise, that I was following the discussion. If one was to look at the foreclosure file, you would see the notice. I mean, you would see the return that was provided by the deputy sheriff. My understanding is that the transfer of the property to KPC and then to National Indemnity occurred before the hearing at which the defect in that service was disclosed. Does the existence of a return of service that's on its face would suggest that there was valid service have any bearing on how this case ought to be decided in your view?
It has been, Your Honor, but the fact that it's not proper to limit a reasonable notice inquiry to the foreclosure file alone, that's not what the law purports. So it's just when you look at outside of the foreclosure file, it becomes obvious, glaringly obvious, that these owners do not know that, for the multiple reasons I said. This, and the public record makes that true constructively. But again, Ms. Schoening testified that she actually knew all those things, that she did what any owner, what any potential purchaser does at a foreclosure sale. Examines to see, are there more taxes and mortgage owed on this property than the property's worth? And they excitedly found, no, there's barely anything owed on this property. And so they went forward with it. And so that I believe is the proper examination of whether they were on notice of a defect. And again, I think the Court of Appeals here gets the Swindell case wrong. That they punt on having to even look at the gross inadequacy. But Judge Bryant properly cites the Swindell standard. It says, when an irregularity is first alleged, gross inadequacy of purchase price may then be considered on the question of the materiality. But what this Court of Appeals did instead was says, no, we think the failure to effectuate service is not a material irregularity. Why? They go on to say, because the Georges have experienced 2 previous foreclosures and are familiar with the procedure. So instead of engaging with this grossly inadequate purchase price that Swindell and Faust say you should, they instead create dicta that says, listen, if you've been in a prior foreclosure, you are somehow entitled to less notice. Your lack of notice is not material. And summarily just avoid even engaging in the question of gross inadequacy of purchase price. That's a departure from the Faust and Swindell standard. And their erroneous reading of Swindell is why they do that, I believe. Judge Bryant correctly cites the Faust case in saying that the finding of gross inadequacy coupled with, quote, any other inequitable element, even though neither standing alone may be sufficient for the purpose, will induce a court of equity to interpose and do justice between the parties. That's what we have here. And that equitable consideration is similar to the consideration that the Stallings v. Carey case puts forth. When it says, even if you've got a purchaser for good faith, a court is allowed to interpose and do justice and say, this is not the right result. We're going to set this aside. No one here is arguing that we should be doing away with the interest of justice analysis in these cases.
Just to make sure, I mean, as you contention that Stallings has continued viability after ACCA?
I believe it does, because ACCA, not only did ACCA took issue with it, but it did not say it's not to be applied, and in fact says, and I quote, assuming Stallings does apply, and then it engages in the interest of justice analysis. And they find out, and they go through the process in the opinion to say, the interest of justice here.
Are you talking about the Court of Appeals decision?
I'm talking about the Court of Appeals decision in ACCA that was then affirmed without opinion by this court.
Well, but what was the issue that was brought forward on the basis of Judge Murphy's dissent? Was it the whole case or one discrete issue?
I believe it was the entire case. Or just the dissent, I believe.
It was just the dissent, and basically, when I reread it, it looked to me like Judge Murphy's said, in effect, oh no, Stallings allows us to look behind it even if there's not a good faith purchase for value, and that was the only issue that was before this court when ACCA was before us. Is that wrong?
Well, I think this court adopting the majority opinion in ACCA is adopting.
Did this court adopt any part of the opinion that was not before it based upon the dissent?
My understanding of the per curiam decision is that it adopts the ACCA opinion as
in its entirety, regardless of whether the portions of that opinion were before the court.
That's my understanding, Your Honor. And that in the ACCA case, they go through the analysis that says the interest of justice in that case is not that the homeowner gets the property back, because there is a mortgage at play in that property. So by parity of reason, conversely true here is there was no mortgage, and a proper application of the interposing of equities in this can and should result in the returning of the property to my client under Stallings or under Faust, Your Honor. So that I don't believe they have established good faith purchaser status. I don't believe there's anything lacking in the record such that we can accuse Judge Poovey of abusing his discretion, and therefore I don't believe they're entitled to that protection. I do want to quickly address the second argument, Your Honor, of due process. If my clients did not receive proper due process, then they should not be deprived of their property. I don't believe they did receive due process for two reasons. One, again, not at issue. They did not receive due process required under our statutes. And two, how ACCA purports to lower the due process standard to consider something less than the statutory requirement. Those facts are not on all fours with our case, and it should not be applied. Further, and speaking of the ACCA case, I think when you look closely at the ACCA rationale and how it purports to stand upon Jones v. Flowers of the U.S. Supreme Court, the rationale and reasoning is tenuous at best. And therefore, I don't believe that the ACCA case should be expanded upon for that reason. If you look at the Flowers case, you see that this is a Supreme Court case coming from Arkansas under the question of, should there be additional due process required in that scenario? Chief Justice Roberts says, well, the Mullane standard has been, we need to have, it needs to be reasonably calculated to reach the intended recipient. But the Jones v. Flowers case is actually about, well, whether or not there needs to be some more efforts. Should there be additional reasonable efforts? And so the whole framing of the Jones v. Flowers case is setting a bar at the bottom and saying this is not sufficient. The court is standing to say there's not sufficient due process here. And it goes on to say you should have taken some more reasonable steps. ACCA then comes in, and what I think the Supreme Court of the United States intended as a shield, a due process shield for homeowners, the ACCA court comes in and uses it as a sword. And I think I want to highlight quickly 2 points where I feel like ACCA misreads and misapplies the Jones case. On page 797 in the ACCA opinion of the Southeast Reporter, it says, quote, a party need not use, quote, due diligence, but rather notice is constitutionally sufficient if it is reasonably calculated to reach the intended recipient, and then cites Jones v. Flowers. Well, the quotes around due diligence make it appear that this is just reading from Jones v. Flowers. Well, due diligence is not required. You just need this. The phrase due diligence nowhere exists in Jones v. Flowers. This is a brand new creation of the ACCA court that says, you know what? due diligence, even though it's required by our statute, it's not required by due process. That does not stand on Jones. That's something that they created. The second place that ACCA misapplies Flowers is on that same page when it says, quote, the Flowers court specifically held where the owner no longer resides at the property, due process is satisfied if notice is posted on the front door of the property. It is nowhere held specifically or otherwise in the Jones v. Flower case, interestingly. What Jones v. Flower is, again, is Chief Justice Roberts saying, here are some additional steps that were reasonable for the tax collector in Arkansas to take. For example, if you've got returned certified mail and no one's there, then it is a reasonable step to post on the property. That's the language that they actually quote, but then they summarily said, this is sufficient. Chief Justice Roberts goes out of his way to say, I am not going to prescribe a form of service of process. I'm just saying this wasn't enough, and here are some of the reasons. But that's where I'm concerned, where the ACCA is opening a door to lower the bar in due process, lower than what our legislature has carefully thought out and has tested and revised as our standard. Nevertheless, even if you do try to apply ACCA to our case, it fails on the facts. It fails because the defect is significantly different. The defect in the ACCA case is a failure of due diligence because they didn't send an email that was on file. And on all fours with the Jones v. Flowers case, they were able to correct that defect by posting on the property and by sending regular mail. Justice Roberts says those are good things to do in that scenario. In the ACCA case, they're able to do that, and they were able to point at the Supreme Court case to say this is sufficient. In our case, our defect is mistaken service. You've got someone erroneously holding themselves out as the owner of the property. And there were no further reasonable steps taken as found by the Supreme Court. There was no posting and there was no regular mail. The regular mail that was attempted here, all of it was returned. We don't have a mailbox rule presumption. They sent regular mail and it came back to the association. It says, this was not delivered. There's no mailboxes there. We know that the regular mail wasn't received. We know that there was no posting. And so in order to apply the ACCA rationale, you would have to expand this lower due process bar to a new set of facts. You would have to be the first.
That you intend to reserve any rebuttal?
I'll probably just try to reserve 2 minutes at the end here, Your Honor. Thank you so much. I felt it important simply to say that this court would be creating a new standard by saying, even if you service is mistaken, even if you serve the wrong person and there's nothing actually to correct that service, you know what? Due process is still okay. You've been satisfied. You can still lose the property. I want to encourage this court to proceed very slowly in expanding a lowered bar of due process where we have a sufficient standard by our state statutes. Thank you, Your Honor. I'll reserve the rest for rebuttal.
Thank you, counsel. We'll hear from the appellate.
May it please the court. I'm Preston Odom, and I practice law with James McElroy and Deal in Charlotte. I represent one of the two appellees in this matter, KPC Holdings. I'm appearing alongside my colleague, Derek Adler of the Devore Acton firm here in Charlotte, and he represents the second appellee, National Indemnity Group. I plan to speak for 25 of our 30 allotted minutes and have Mr. Adler close with a few arguments specific to his client. The first thing that jumped out to me in getting prepared for this argument is that it's exactly 4 years ago to the day, and almost to the hour, it's almost 2 o'clock, where this sale took place in the Mecklenburg County Courthouse, where my client was the high bidder on January the 12th of 2017. I just thought that was an interesting point, serendipitous. That sale, where my client was the high bidder, happened in a manner that, and I'm going to use what Mr. Galvin said, at the trial court level during the July 17, 2017 hearing. He said that the trustee followed pretty much the book of what to do here in terms of serving notices during the non-judicial foreclosure proceeding that preceded the public sale that my client bid at. We believe that with that background, and that's all the record shows, is that my client could rely on the facial validity of the record to be a bidder at a public sale of the property at issue. We think that there's really three overarching arguments or issues for this court to confront. The first one is jurisdictional in nature. The appellees have moved to dismiss the appellant's appeal on both grounds under 7A-30 that they've moved under. We filed that motion back in March of 2019. They never responded to it. They didn't brief it, and they didn't address it in the oral argument. But we think that there are fundamental jurisdictional defects that this court needs to address before even possibly reaching the merits of determining whether the majority opinion below was correct. The appellants have cited both grounds under 7A-30 in support of their appeal. The first ground deals with whether there's a substantial constitutional question at issue in this case. And as we set forth in our motion to dismiss, there's not, because the In Re Aca decision conclusively decided these very issues in this case 2 years ago. And Justice Irvin, to your question about the scope of your court's affirmance per curiam in In Re Aca, it affirmed based on what issues were before the court, and that is in dispute between the majority decision in that case and the dissent. Interestingly, Judge Dillon at the Court of Appeals authored the In Re Aca majority at the Court of Appeals and was also on the panel in this case and wrote a concurring opinion. In the In Re Aca case, it did disavow the necessary and the interest of justice standard that was set forth in the Town of Cary versus Stallings case. That's evident from...
Mr. Odom, just to follow up on that a second, when I went back and looked at ACA in preparation for argument, it appeared to me that the issue that was before us in that case simply was whether under Stallings, the court had the right, even in the event that a particular entity or person was a good faith purchaser for value, to set aside a sale. That was the only issue that was before us in that case. In your view, is that wrong?
No, sir. I believe that's right. I think what ACA stands for and what this court affirmed was that where you have a party that's received constitutionally sufficient notice, then a purchaser at the public sale is a purchaser in good faith, then the relief a trial court can grant if there was not statutorily proper service is solely in the form of restitution as set forth in 1-108, and you can't disturb title.
So that at least as far as by the time that ACA got here, the issue of whether there was constitutionally sufficient notice was not before us, and the issue of whether the party, the appellee, was a good faith purchaser for value wasn't before us either. Just simply what authority does a court have given constitutionally sufficient notice, given the presence of a good faith purchaser for value?
Yeah, I don't actually think there was any dispute between the majority and the dissent in ACA about whether there was constitutionally sufficient notice in that case. I think it was the remedy that can apply if you have constitutionally sufficient notice and a good faith purchaser. Can you disturb title to that purchaser acquired at the public sale, which is exactly what we have here. So we believe that.
Except that here, even putting aside your motion to dismiss on the grounds that there's not a sufficient constitutional question, we do have squarely presented by Judge Bryant's dissent the issue of whether both your client and Mr. Adler's clients were good faith purchasers for value for purposes of GS 1-180. We do have that squarely before us, don't we?
I believe you have that squarely before you, but it's only reachable by way of the dissent. It's not part of the substantial constitutional question analysis.
But you have not contended that the case is not properly before us on the basis of the dissent, have you?
I actually have, Your Honor.
Okay.
Our motion to...
Go ahead.
Okay. Our motion to dismiss first contests the viability of the substantial constitutional question prong. It then challenges the notice of appeal based on the dissent because under 7A-30 subsection 2, it says that and I'll read it, an appeal of right pursuant to this subdivision is not effective until after the Court of Appeals sitting en banc has rendered a decision in the case, if the Court of Appeals hears the case en banc, or until after the time for filing a motion for rehearing of the cause by the Court of Appeals has expired, or the Court of Appeals has denied the motion for rehearing. In this case, the decision of the Court of Appeals below was issued on February the 19th, I believe, and 13 days later, the appellants filed both of their notices of appeal. That was before the time expired for any motion for rehearing en banc under Appellate Rule 31.1.
Which was never solved, is my recollection.
That's correct. That's correct, Your Honor. But under 7A-30 subsection 2, it says that, in essence, you don't have a right of appeal until the time is expired for moving to rehear en banc. So when they filed their notice of appeal, they didn't have a right to do so. And they never followed that up with filing a notice of appeal after the expiration of that requisite time. So we contend that this appeal is not properly before this court under 7A-30 subsection 2. We also cited a treatise that gives gravity to that in the motion to dismiss. So again, we've moved to dismiss both bases of their appeal before this court, and they've never challenged that. And we think that silence lends gravity to our arguments on that point. With respect to the substantive issues, we have the issue of whether there was constitutionally sufficient notice, and then whether my client, KPC Holdings, was a good faith purchaser at that foreclosure sale. I'll let Mr. Adler address the status of his party, of his client, to which my client conveyed the property afterwards. And as you noted, Justice Ervin, before the Georges moved to set aside anything and raise any prospect of a problem with service. With respect to the constitutionally sufficient notice prong, there actually wasn't a dispute at the Court of Appeals level about whether the appellants received constitutionally sufficient notice. Judge Zachary in the majority opinion and Judge Dillon in his concurring opinion both found constitutionally sufficient notice that the appellants had received that, and Judge Bryant didn't dispute that. So Judge Bryant's dissent only is with respect to whether on the good faith purchaser issue. So we think that constitutionally sufficient notice is established. And Mr. Galvin, in arguing about Enriaca potentially misreading the Supreme Court of the United States decision in Jones, it's a roundabout way of actually asking this court to reverse Enriaca and also Enriaca's disavowal of the Town of Cary versus Stallings case. We think that the notice in this case is to the appellants is actually much stronger than the notice that was at issue in the Enriaca case. In this case, if you went and studied the not just the foreclosure file, but the record outside of the foreclosure file, there would have been no evidence of any problem with service. Mr. Galvin points to the deed that the Georges had back in March of 2013, which lists both the property address and the U.S. Virgin Islands address that the trustee in this case used to try to effect service. Interestingly, in one of those prior foreclosures that Mr. Galvin mentioned, the notice was served at the very same property that service was accomplished in this case. I guess, so if you're looking at that record, then you would think that the sheriff properly served the notice in this case as well. So there was nothing to suggest that there was any problem with service. The Deputy Barnes certificates of service that were in the file is what prompted the clerk of court to enter an order saying that they had received proper notice under Rule 4. I'm at a loss as to what the appellants want a bidder at a public sale to do, and doing their due diligence and scouring the file to essentially disbelieve the certificates by the deputy and the clerk's order saying that there was notice. It's strange credulity to make that argument, especially based on this. The state of this record, the tax records that Mr. Galvin mentioned also list the property address where Deputy Barnes made the personal service in this case. So if they had paid their taxes at the end of 2016, then it stands to reason that they might have gotten notice at their property address where service was accomplished in this case. Again, there was nothing that anyone with a reasonable view of the file would suggest that there was a problem with service.
Sorry to interrupt you, but I want to get your views on whether you agree that this question of whether your client was a good faith purchaser is reviewed for abuse of discretion on the part of the trial court. Is this a factual determination the trial court made that we owe deference to?
Your Honor, I don't think that is a factual issue. I think that would be a mixed question of law or fact that would be reviewed de novo on appeal. The Court of Appeals, based on the record, the majority found that there wasn't sufficient evidence or a finding of fact to support a determination that my client was not a good faith purchaser at that sale. The only evidence that could suggest that they rely on is the amount of money that my client bid at the foreclosure sale. There's no evidence of any untoward, depression of bids or anything that Mr. Galvin just voiced for the first time during this oral argument. That's never come up in any of the prior proceedings in this case. My client was the high bidder, and my client, KPC Holdings, bid the amount necessary to satisfy the community association's lien, as well as all of the costs associated with the sale. So there was nothing preventing anyone in the world from placing a bid on this property. And also remember that within days of the sale that occurred on January the 12th, there was an email to the trustee's office sent from someone purporting to be Mrs. George, asking for the reinstatement quote to bring current and do away with the foreclosure sale. The trustee immediately responded that day with the amount required, and there wasn't anything ever paid. So there wasn't a reinstatement, and there wasn't an upset bid. That had nothing to do with my client.
That was what I was going to ask you, Mr. Odom. Is there was your client aware of this email exchange between the trustee and the person who identified themselves as Ms. George?
Your Honor, there's nothing in the record that would show that my client had any knowledge of that email.
My understanding of what we're supposed to look at in determining whether your client knew or should have known that there might be a service problem is essentially what was available, what your client actually knew, and what your client could have just gleaned from a review of the public record. Is that the scope, the universe of information that we ought to be looking at?
Yes, Your Honor. I do believe that what you'd have to look at is if you went to the file on January the 12th of 2017, or before that sale was conducted by the trustee, what would you find to give any evidence that there was a service problem in this case?
Is your argument that you should look solely at the file maintained with respect to the Homeowners Association's foreclosure proceeding or the public record in general?
I think, Your Honor, I don't think the cases distinguish between that. I think that whether you look at just the foreclosure file or everything of record with respect to this property, there wouldn't be any constructive notice or actual notice of any problem with Deputy Barnes' service of the foreclosure notice and notice of sale in this case. Absolutely nothing. The appellants speculate and rest on conjecture that no one in the world would bid at this foreclosure sale if they had known that the property was free and clear and there was a small amount of claim of lien that was being foreclosed on. But that, if you took that to its logical extension, we wouldn't have bids in any HOA or community association foreclosures, because usually those are in, the claim of lien amounts are small, and whether a property is unencumbered, or let's say there's a community association that has a $500 in outstanding dues from a homeowner whose home is worth $5 million and has a $3 million mortgage on it. Well, there's $2 million of equity that could be at issue if there's a foreclosure. And so we couldn't have a foreclosure or a bid in that instance under the appellant's rationale. Just no one would bid at any sale, and that would stifle and undermine the process that the General Assembly has set out. The General Assembly has not established a minimum bid amount requirement or put some after-the-fact overlay of whether the price bid at the sale is sufficient. The bidding process itself is supposed to engender the bids to raise, and there was nothing in this case that would show that my client had anything to do with any bid suppression. There's absolutely nothing in the record. And that dovetails into the good faith prong of this. On the good faith prong, it overlaps with the constitutionally sufficient notice prong. My client and National Indemnity Group argued that there was actual service in this case because the property where Deputy Barnes served the foreclosure notice and notice of sale was owned by the Georges, and someone who spoke with Deputy Barnes purported to be Mrs. George. And so when you have the person that purports to be the record owner and the wife of the other record owner, then Deputy Barnes would reasonably believe that effective service had been accomplished. And in bidding at the sale, my client acted in good faith based on the state of the record and paid the amount sufficient to cover everything that needed to be covered from the foreclosure perspective. My client didn't do anything to, again, suppress any bids or and interestingly, in the writ of possession that Mr. Galvin mentioned, that same writ of possession was served at the very same property where Deputy Barnes served the foreclosure notice and the notice of sale. And somehow the Georges found out about the writ of possession. You would think that they would also learned much earlier about documents served at the very same address. So, you know, again, looking at the file, there was nothing that would give rise to any doubt that there was a perfect service in this case.
What's your response to the other side's position that the low amount relative to the equity that was in the house should have put your client on notice that something was amiss?
Your Honor, the low amount of the claim of lien itself?
Yes, that relative to the equity, the 99% discount that was deemed to be ultimately what your client was able to get by virtue of this purchase price, in terms of being put on notice that there was something that was amiss with all of this.
Yes, Justice Morgan. Again, I think that if you take that, that would apply across the board in just about all non-judicial foreclosures that are pursued by community associations or condominium associations. They're usually in low amounts like this, and to accept their position, that would mean that every bidder would have to have necessarily a suspicion that there was a notice problem if there's being a sale conducted, and we just don't think that that's the appropriate analysis.
Well, in terms of talking about a gross inadequacy, would you disagree that 99% is sufficiently gross to bring up this potential, or are you saying that no matter what the amount might be, nonetheless, because of the typical disparity between actual value and purchase value, that no purchaser for value should ever be put on any notice like this?
Your Honor, I think that the latter point, that if you have a low amount that's being foreclosed on, that doesn't in and of itself, and then you have some value that you think is in the property, I don't think that in and of itself gives rise to any reasonable question about whether notice was proper on the front end. I mean, if that's the case, then the clerk should not be entering any orders in any case where this type of argument could be raised. You're placing the onus on a bidder after the fact when the clerk has already passed upon the question. And so a bidder at the foreclosure sale that's been permitted to go forward by the clerk should be able to rely on what the clerk has done if there's no other indicia of problems in the underlying service, like in this case, where you have deputy sheriff's certificates of service that are presumptively valid. And I see that I'm cutting into Mr. Adler's time, so if the panel doesn't have any other questions, I'll turn it over to him.
Mr. Adler, we can't hear you. Are you muted? Fred, can you help us out? Or Mr. Adler, are you muted?
I'm not muted.
Okay,
Can you hear me?
Go ahead.
Yes, Justice Morgan, chapters 45 and 47F, there's no threshold requirement to conducting a foreclosure. It can be a $200 claim of lien. It can be a $10,000 claim of lien. There's also no threshold for an amount that has to be bid at foreclosure. There's no guaranteed equity return in those statutes. The bidding was open. It ended at $2,600 and change, but there's nothing that prevented it from going higher. But to kind of dovetail into National Indemnity's argument, this argument isn't really relevant until you get past Mr. Odom's argument. If he's done a successful job of convincing you that KPC Holdings was properly conveyed the property, then everything I'm going to tell you is irrelevant. So if you assume, though, that KPC Holdings was not properly conveyed the party, if you assume that NREACA does not apply, if you then say that Swindle v. Overton does not apply, then we get to this point of the argument. And that is with a fourth party purchaser, National Indemnity Group, that was in essence an innocent purchaser. And one thing I'd like the court to consider when thinking about this is, what is this case not? It's not a case of fraud against National Indemnity Group. It's not a 60B3 motion alleging fraud and collusion. Mr. Galvin admitted the collusion was not proven. That's not what this case is about. But if you were going to disturb the conveyance to National Indemnity Group, that's what this court would have to find. That issue is not before this court, that issue was not raised at the trial court, and that issue was actually decided in favor of National Indemnity Group with the findings of fact. We just believe that there were conclusions of law that were misstated. But the facts here are synonymous and parallel those of what happened in the Goodson case, which Mr. Odom has cited in his brief. And that was a situation where you had a forced sale via court that two attorneys were appointed as commissioners to sell and parcel out property, except the attorney commissioners forgot to give notice to one of the co-owners of the property. What the court said there was, well, it was sold. An innocent purchaser paid value. It's the same thing that was done in this case. And then the prior owners came forward and said, hold on, that's not proper. We never got notice of this. And in Goodson, the court acknowledged. They said, yes, you're right. You did not get proper notice of it. However, we will not disturb the good faith purchase of the purchasers. But it didn't leave them without a remedy. In the Goodson case, they still said that we are remanding back to the trial court because there was still negligence or potential negligence on a part of the attorney commissioners. And so the prior owners who did not receive that did not receive service still had a remedy. And the reason I bring up that remedy component, that's a critical aspect, I think, to the decision in ACA and in the lower court's decision here. And that is simply that the petitioners, the Georges here, are not without a remedy. And ACA lays the landscape for how to do that, and that is with restitution from the Homeowners Association. The Homeowners Association is the party that is intended to benefit from a foreclosure. Therefore, they should be the party that bears the risk if the party isn't properly conducted. The Court of Appeals affirmed voiding of the foreclosure. The HOA did not appeal that finding in the trial court level or above, and therefore we believe that issue is set. So under the guidance of NREACA and the Court of Appeals in this matter, this would then be remanded for a finding of potential restitution from the Homeowners Association. What it is not a finding that National Indemnity Group and KPC Holdings somehow colluded with the HOA to do this, to undermine the foreclosure process. It was an open bidding that was, accessible by the world, as Mr. Odom has evidenced. Well, we know that there's a $150,000 promissory note, and there's a deed of trust that is of record. And that is what the court should focus on when realizing that National Indemnity Group here has done nothing wrong. They come in after the fact. The petitioner, if the petitioners get their argument, they want this court to authorize lookbacks for any property that was purchased for value and determine if their seller had paid enough for it. And that's not how real estate transactions are supposed to work in North Carolina. In this case, KPC Holdings had proper title. It was given to them by a sheriff's deed, and they properly conveyed it. I see my time is up. I thank you for your time. I'd be happy to answer any questions.
Thank you, counsel. Any rebuttal?
Yes, Your Honor. I want to address what I consider fear-mongering on the side of the respondents. They purport that if for some reason this sale gets set aside, that no one else is going to show up to bid at foreclosure sales. There is no universe where foreclosure sales can never be set aside. Rule 60 allows it. 1-108 allows it. And that will always be true. And there will always be bidders to show up. In fact, if there's a chance of buying a property at 1% of its value, you're going to line up. That's not an issue here. The reality is, if in fact you do get something at a grossly inadequate consideration, you are on notice. And specifically here, you're on notice, but for the three reasons I stated, that you know what, there may be a problem with notice. And I won't be surprised if the owner who paid off their mortgage and paid their taxes and let 6 figures of debt, 6 figures of equity walk away for a $200 debt, I'm not going to be surprised if they come back. Now, you don't get to just come back, which is why, again, it's a safe situation. There has to be some other problem. Here, the other problem was they weren't served. That's not even an issue before this court. They did not receive statutory service. There was not personal jurisdiction exercised over Calmore George. The court can and should, in situations like this, do justice. So no, tomorrow, yesterday, next week, there are going to be bidders that show up and bid. All the more so if they are able to find these good deals. It's not going to have any sort of chilling effect. There's always going to be that chance. The law allows an avoidance of the harsh result that the Court of Appeals referenced 3 times here. We have an avoidance of it. Gross inadequacy, and lack of actual notice. The court can do justice here, especially when the standard is abuse of discretion. The Court of Appeals in this case said, yes, the standard is abuse of discretion for Judge Poovey, and we just summarily find that he abused his discretion, and that followed the erroneous arguments that I think that they made. And so, yes, I think these deeds can and should be set aside, and the world will be okay.
Thank you, counsel.
Thank you.
Thank you to everyone. Appreciate your arguments today, Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning. God save the state and this honorable court. Counsel, thank you for your time.